All right, welcome in everyone to the deep dive. We're getting into some seriously important stuff today if you happen to be renting in LA, so listen up.
You got it. It's tenant rights all the way.
We've been combing through legal briefs, FAQs from lawyers who specialize in this stuff, and of course the latest updates on California rental laws.
Yeah, lots to unpack.
We're going to lay it all out. Your key protections as a tenant, when you might actually have a case to take your landlord to court, how that whole eviction process actually works, and a bunch of big changes that are coming into effect in 2025.
Definitely some big shifts on the horizon.
The goal here is pretty simple, right? We want to make sure you know exactly what your rights are and what you can do if you feel like those rights aren't being respected.
Knowledge is power, especially when it comes to something as essential as your home.
So let's just dive right in. What really struck me going through all this material was how strong the legal protections are for tenants here in Los Angeles and all across California.
Yeah, for sure. It's not just talk. There are actual laws on the books designed to protect you from things like wrongful eviction, harassment from your landlord, unsafe living conditions, even discrimination.
So it's not just about feeling bad or uncomfortable, it's about having legal recourse. Okay, let's get into specifics here. When is it actually a situation where you might want to consider suing your landlord here in LA?
So our sources are really clear about a few scenarios where you might have grounds for legal action. One of the big ones is when a landlord just fails to maintain a habitable property, like they just don't keep the place safe and livable.
Okay, so what does that actually look like? Can you give us some examples?
Sure. So think about things like a major infestation of pests like bed bugs or rodents, or maybe there's serious damage from something like a fire or a flood, or even just really bad leaks that they're not taking care of.
That makes sense. You're paying to live somewhere. It should be at least livable.
Right. The law backs that up. Landlords have a legal responsibility to provide a habitable environment for their tenants.
Now, it's not just about the physical building itself, though, right? What if the landlord's negligence leads to you getting injured on the property?
Absolutely. If you get hurt because of something the landlord was responsible for, like maybe you trip on broken stairs that they knew were dangerous, or there's some other hazard they just ignored, that could definitely be grounds for a lawsuit.
So you're saying if their carelessness leads to you getting hurt, you have legal options?
You got it. And it goes beyond obvious neglect, too. What about things like exposure to hazardous materials? Things you might not even know are there.
Yeah, that's scary.
Right. Like if you've been exposed to asbestos or lead or even carbon monoxide because your landlord wasn't careful, that's a serious problem. You have every right to seek legal help in those situations.
Those are some really serious health risks.
Yeah, and the law recognizes that. Landlords have a duty to protect their tenants from those kinds of hazards.
Now, what about those situations where a landlord just seems to be trying to force you out without a good reason?
Right, so that's where we get into wrongful or forcible eviction, which is totally illegal and can be a strong reason to take legal action.
Can you give us some examples of that?
Sure. One classic example is when a landlord just decides to change the locks on you without a court order. They just want you out, so they take matters into their own hands. That's what's called a self-help eviction, and it's completely against the law.
Wow, so no DIY eviction tactics?
Nope, not allowed.
Yeah.
And if you're renting a place that isn't even legally permitted for people to live in, maybe it doesn't meet safety codes or something, you might be able to take legal action against the landlord in that situation too.
It sounds like the law really has your back in those cases. Okay, the last point in this area that really stuck out to me was landlord harassment. What does that actually mean, legally speaking?
Landlord harassment is basically when your landlord deliberately tries to make your life so miserable that you feel forced to move out, but they're not going through the proper eviction process.
So they're trying to push you out without actually evicting you.
Exactly. They want to bypass the legal system. And it can take different forms. It could be direct intimidation like threats or just constant harassment.
Okay, so that's the in-your-face kind of harassment. What about the more subtle stuff?
Yeah, so it could also be things like deliberately cutting off your essential utilities, like your water or electricity. Or maybe they just constantly enter your property without proper notice or a good reason.
I see. They're trying to make it so unbearable that you just give up and leave. So if you suspect your landlord is pulling any of this, what should be your first move?
Documentation, documentation, documentation. That's your first and most important step. I can't stress that enough.
So you're saying get everything on record?
Yep. Take photos and videos of any problems, like if there are pests, leaks, damage, anything like that. Keep copies of every single communication you have with your landlord, whether it's emails, text messages, letters, whatever.
That makes sense. You need to be able to prove what's been happening.
Right. And if you've had to report any issues to the city, or if you've had to go to the doctor because of the conditions in your rental, keep those records too. Everything helps.
So once you've gathered all this evidence, what's the next step?
Reach out to a tenant rights attorney. And I mean like right away. The sooner the better.
So you're saying get legal advice as soon as possible.
Absolutely. Here in Los Angeles, there are a lot of attorneys who specialize in this area of law, and many of them offer free consultations. So you can sit down with them, explain your situation, and they can tell you what your rights are and what your legal options might be.
Okay, so there's no harm in just having a conversation with an attorney.
Exactly. You can find out where you stand and what you can do.
Now, I think a lot of tenants worry about the cost of hiring a lawyer. What's the deal with that?
Yeah, that's a valid concern. A lot of tenant rights firms, especially the ones that specialize in this kind of work, understand that. They often work on what's called a contingency fee basis.
What does that mean?
Basically, it means you don't have to pay any fees up front. The attorney only gets paid if they win your case or if you reach a settlement.
So it's like a no-win, no-fee kind of deal.
Exactly.
Yeah.
And that can really help to make legal help more accessible for tenants, especially if they've been dealing with a difficult situation.
Okay, that makes a lot of sense. Now, let's talk about the eviction process itself. The official way a landlord has to go about evicting a tenant. In legal terms, it's called an unlawful detainer action.
Right. So if a landlord wants you out, they can't just tell you to leave and change the locks. They have to follow a specific legal process, and that's the unlawful detainer.
So there's no cutting corners or taking the law into their own hands.
Nope. Self-help evictions are illegal, and tenants have legal protections against that kind of thing.
All right, so the first step for a landlord usually involves giving some kind of written notice, right?
Yeah.
What are we talking about here, and how much time does a tenant typically get?
The type of notice you get depends on the reason why the landlord's trying to evict you. If it's for unpaid rent or some kind of lease violation, you usually get a 3-day notice.
A 3-day notice to do what?
It's either a 3-day notice to pay rent or quit, or a 3-day notice to fix the violation or leave. Basically, they're giving you 3 days to either resolve the issue or move out.
Okay, that makes sense. But what if the eviction isn't because you did anything wrong?
Right, so those are called no-fault evictions. Maybe your lease is up or you're on a month-to-month agreement and the landlord just wants you out. In those cases, you're usually entitled to a 30-day notice if you've lived there for less than a year, or a 60-day notice if you've been there for a year or more.
Okay, so you get more time if you've been living there longer.
Exactly. Now, what happens if a landlord does go ahead and file an unlawful detainer lawsuit, after giving you the notice?
What are your rights at that point?
Well, the first thing is that if you get served with an unlawful detainer, summons and complaint, you have to respond to the court. And there's a really important change happening in 2025 regarding that.
What's changing?
You used to only have 5 court days to file your response. But starting in 2025, that's been extended to 10 court days.
Okay, so that's double the time.
Yep. And if you were served by mail, you get 5 extra days on top of that, so you'd have 15 court days total. And keep in mind, those are court days, so weekends and holidays don't count. That can give you a bit more breathing room.
I bet that extra time can be really helpful for tenants who are trying to figure out what to do. Now, what if you live in one of those rent-controlled areas of Los Angeles? Are there any extra protections there when it comes to eviction?
Yes, in rent-controlled areas of the city and county, landlords have to have what's called just cause to evict you.
What does that mean?
Basically, it means they need a legally recognized reason to end your tenancy, even if your lease is up or you're on a month-to-month agreement.
So they can't just kick you out for any random reason.
Yeah. Exactly. Like wanting to raise the rent above the legal limit isn't a good enough reason. But if you're not paying rent or you've caused significant damage to the property, that would likely qualify as just cause. It adds another layer of security for tenants in those areas.
So that's great to know. And it's important to remember that landlords can't just evict you as retaliation, right? Like if you ask for repairs or report them for violations, they can't just kick you out for that.
Absolutely. Retaliatory evictions are illegal. They also can't discriminate against you based on things like your race, religion, family status, disability, things like that. Those are protected characteristics. If you think you're being evicted for any of those reasons, that's a really strong legal defense.
It sounds like you have a lot of options if you believe your landlord is acting illegally. So let's talk about some of the main legal defenses a tenant might have if they're facing eviction.
Okay, so one of the most common defenses is improper notice. We talk about how landlords have to follow very specific rules when they serve you with that eviction notice.
Right, like what it has to say and how it has to be delivered.
Yep. If they mess any of that up, it could be enough for the court to dismiss the whole case.
So it's worth paying close attention to that notice.
For sure. Another major defense is if the rental property is just in really bad shape, like it's not habitable.
We touched on that earlier. Can you elaborate on that a little more?
Yeah, so landlords are legally obligated to make sure your home meets basic health and safety standards. If you've notified them in writing about serious problems like mold, pest infestations, lack of heat or hot water, and they haven't made an effort to fix them, that can be a defense against eviction.
So you're saying if they're neglecting their responsibilities, you might be able to use that to your advantage.
In some cases, you might even be able to withhold rent until they fix the problems. But it's really important to get legal advice before doing that, because there are very specific rules about how and when you can withhold rent.
Okay, good to know. What about those situations where the eviction seems like it's motivated by discrimination or retaliation?
If you can prove that the eviction is happening because of your race, religion, national origin, family status, disability, or any other protected characteristic, or if it's retaliation for you asking for repairs or reporting a violation, that's a very strong defense.
So it's really important to keep good records of everything?
Definitely. You need that evidence to support your claim. Now let's switch gears and talk about some of the big legal changes coming in 2025 that tenants in Los Angeles need to know about.
Yeah, there are some big ones coming up.
We're talking about changes to security deposits, rental application fees, credit reporting, and those fees for serving notices.
Lots to cover.
Let's start with security deposits. There's a new law, AB 2801, that's going to have a big impact on how landlords can handle those deposits.
Okay, what's the change and how does it protect tenants?
So, starting in 2025, if a landlord wants to keep any part of your security deposit, they can't just give you a list of deductions and a written explanation.
Right, they have to itemize everything and explain why they're keeping the money.
Yep. But now they also have to provide photographic evidence to back up their claims.
So no more shady deductions without proof.
Exactly. As a tenant, you now have a much stronger position to challenge any deductions that seem unfair or made up. And it's a good idea to take your own detailed photos of the place when you move in and move out. That way, you have your own evidence to compare.
That's a game changer for tenants. So when do these new photo requirements actually kick in?
It's a phased rollout. Beginning on April 1st, 2025, landlords will need to have photos of the property after you move out and after any repairs or cleaning are done. Then, starting July 1st, 2025, they'll also need photos from the very beginning of your tenancy before you even move in.
So we're talking about 3 sets of pictures for every rental.
At least 3 sets, yeah. It's all about transparency and accountability.
That's a big step forward in protecting tenants. Now, what about those rental application fees? It sounds like AB 2493 is bringing some changes there too.
Right, so AB 2493 is all about making the application process fairer and less expensive for renters.
How so?
Well, first of all, landlords will only be able to collect application fees for properties that are currently available or will be very soon. They can't just collect fees from a bunch of people for a property that's not even open yet.
That makes sense. You shouldn't have to pay to apply for a place that's not even an option.
Exactly. And landlords will have to give you their screening criteria up front so you know what they're looking for in a tenant, like what's the minimum credit score or income they require.
That's good. It gives you a chance to decide if it's even worth applying.
Right. Now, the refund rules depend on how the landlord handles applications. If they review them as they come in and pick the first qualified applicant, they have to refund the fees to anyone else who met their criteria but wasn't chosen.
Okay, that seems fair. What about if they wait to get a bunch of applications and then try to pick the best one?
In those cases, they have to refund the fees to all the applicants who weren't selected, whether they met the criteria or not.
So they can't just profit off a bunch of application fees if they're only going to pick one tenant.
Exactly. It's about protecting tenants from unnecessary expenses.
That's great. Now, we've already discussed AB 2347, which gives tenants more time to respond to an eviction lawsuit. Let's talk about AB 2747, which deals with positive credit reporting. How does that work, and how can it benefit tenants?
So AB 2747 gives tenants the option to ask their landlord to report their on-time rent payments to credit bureaus.
So instead of just paying rent and hoping for the best, you can actually get credit for it.
Exactly. It can help you build or improve your credit history, which can be really helpful for getting loans or even renting another place in the future.
That's awesome. So it's up to the tenant to request this reporting.
Yes, it's optional for the tenant. Landlords can charge a small fee, up to $10 per month, to cover the cost of reporting, but they have to offer the option.
Okay, so it's not automatic. You have to ask for it.
Right. And there are some exceptions, like smaller landlords who own 15 or fewer units and aren't owned by a big corporation are exempt from this requirement.
Gotcha. And finally, what about SB 611? That one deals with those pesky fees for serving notices.
Yeah, SB 611 is pretty simple. Landlords can't charge you a fee for giving you notices to end your tenancy.
So those 3-day notices, 30-day notices, 60-day notices, they all have to be free.
Exactly. It's considered part of the landlord's cost of doing business, and they can't pass that cost on to you.
That's another win for tenants. Okay, let's talk about something that can be a real nightmare for renters. Landlord harassment. Can you break down what exactly that means in a legal context?
Sure. Landlord harassment is basically any action a landlord takes to try to force you out without going through the legal eviction process.
So like we talked about before, it's about them trying to circumvent the law.
Exactly. It can involve direct tactics like threats or intimidation, or more indirect things like cutting off your utilities or constantly showing up at your place without a good reason.
So the key is their intent to make you leave without actually evicting you.
Exactly. And the good news is that this kind of behavior is illegal, both under California law and here in Los Angeles.
Really? So there are laws specifically against landlord harassment?
Yep. In fact, the city of Los Angeles has a tenant anti-harassment ordinance that spells out all sorts of behaviors that are considered illegal.
So it goes beyond just the general state laws.
Right. The city ordinance often provides even stronger protections for tenants.
That's good to know. So if a landlord is engaging in this kind of harassment, what can a tenant do about it?
Take legal action. You have every right to sue your landlord to get them to stop the harassment and to get compensation for any damages you've suffered.
So you can actually take them to court for this?
Absolutely. And remember, documentation is key. Write down every single instance of harassment with dates, times, any witnesses, and what exactly happened.
So it's not just about feeling harassed, it's about having proof of what's going on.
Exactly. The more evidence you have, the stronger your case will be.
We've been talking a lot about tenant rights in the city of Los Angeles. What about the unincorporated areas of Los Angeles County? Are there similar protections in place there?
Yes. Los Angeles County also has a rent stabilization and tenant protection ordinance that applies to those unincorporated areas.
So it's like a county-level version of the city ordinance.
Pretty much. It also regulates rent increases and requires just cause for evictions, and it has provisions to protect tenants from harassment and retaliation. So no matter where you live in LA, you've got some strong legal protections.
It sounds like there's a lot to keep track of. It really makes you realize why it's so important to have a lawyer on your side if you're facing eviction or any kind of dispute with your landlord.
Oh, absolutely. This area of law can be really complex, and landlords often have their own lawyers. So it's important to have someone in your corner who knows the ins and outs of the system and can fight for your rights.
You're saying it levels the playing field.
Exactly. And remember, a lot of tenant rights firms work on that contingency fee basis, so you don't have to worry about paying those big upfront legal fees.
We talked earlier about how landlords have to follow the legal process for eviction, but what happens when they try to take shortcuts? What are some of those illegal eviction tactics we should be aware of?
So the big one is what we call self-help evictions. This is where the landlord tries to force you out without going through the court system. Things like changing the locks, shutting off your utilities, removing your belongings. Those were all illegal.
So even if they're frustrated or think you're in the wrong, they still have to follow the legal process.
Absolutely. And if they don't, they can be held liable for some serious damages.
So if a landlord tries to pull any of those illegal moves, it's crucial to document everything and contact a lawyer right away.
Couldn't agree more. You have legal recourse if they try to take the law into their own hands. Now, what happens if the landlord does everything by the book and actually gets an eviction judgment against a tenant? Are there any options left at that point?
That sounds pretty final.
It might seem that way, but there might still be some things you can do. For example, you can file a motion to ask the court to set aside the judgment.
Okay, so you're saying you can challenge the judgment?
Yeah, but only under certain circumstances. Like if there were procedural errors in the case, or if you weren't properly served with the lawsuit, or if there are other legal grounds to challenge it.
I see. So if there was something wrong with the process, you might have a chance to fight back.
Exactly. And you can also request what's called a stay of execution, which is a court order that temporarily puts the eviction on hold.
So it buys you some time.
Right. It gives you more time to move out or maybe even try to negotiate a settlement with the landlord. But these post-judgment actions can be pretty complicated, so you really need to get legal advice as soon as possible if you're in this situation.
This has been a really informative deep dive into tenant rights. Are there any groups of tenants who have additional legal protections, maybe because of their circumstances?
Yes, definitely. There are some groups that are considered more vulnerable and often have extra legal safeguards.
Who are we talking about?
Families with children, elderly tenants, people with disabilities, and tenants who receive housing assistance, like Section 8.
So the law recognizes that these folks might need extra protection.
Exactly. For example, landlords have to make reasonable accommodations for tenants with disabilities, and there are laws to prevent discrimination against families with children. It's important for those groups to know their rights.
Absolutely. Now, before we wrap up, I want to touch on something we talked about earlier. The possibility of negotiating with a landlord to avoid going to court.
Right, so sometimes it's possible to work things out without having to go through a whole legal battle.
How does that work?
Well, a good tenant rights attorney can be a really skilled negotiator. They can often help you reach a settlement with your landlord that works for both sides.
So instead of fighting it out in court, you can try to find a compromise.
Exactly. It might involve things like negotiating a payment plan for past due rent, agreeing on repairs that need to be made, or even working out a move-out agreement that protects your rental history.
So even if things seem really bad, it's worth exploring those options.
Definitely. Having a lawyer by your side during those negotiations can make a huge difference. They understand the law, they know your rights, and they can advocate for your best interests.
That makes sense. Okay, we've covered a lot of ground today. What's the most important thing you want our listeners to take away from this deep dive into tenant rights?
Well, the main takeaway is that if you're a tenant in Los Angeles, you have rights, and you need to understand them, especially with all these new laws coming in 2025.
Right. Things are changing, and it's important to stay informed.
Exactly. If you think your rights have been violated, document everything. Make sure you understand the eviction process, and don't hesitate to get legal help if you need it.
And for more information and resources, you can visit martinezlawcenter.com. They specialize in representing tenants and have a ton of helpful information on their website.
That's a great resource.
Okay, so with all these protections and avenues for legal recourse, it makes you wonder, how might this shift the power dynamic between landlords and tenants in Los Angeles moving forward? And what steps can you take as a tenant to make sure your rights are being respected? Definitely some food for thought.
Absolutely. Knowledge is power, and knowing your rights can make all the difference.
Thanks for joining us for this deep dive. We'll see you next time.
Take care.
Call now 714-442-9741. Thank you.